Hello and welcome to Rough Diamond, our video update for pension trustees and employers on what's going on in the world of pensions at the moment. In this series of Rough Diamonds, we're going to be looking at the changes introduced from April for DC pension schemes. And in this particular episode, I'm going to be looking at default investment arrangements, good value, and the appointment of a chair. If you'd like to know more on this subject, we've published a guide for trustees. You can access that from our website. So let's start off with the default investment arrangement. The law now requires you to produce a written statement of investment principles. At the very least, this must cover the aims and objectives of your default investment arrangement and explain how these are intended to be in the best interests of your membership. You have to review your default investment arrangement and therefore your SIP no less frequently than every 3 years, although more frequently if changes require it. And it's arguable if the April changes themselves are enough to require you to review your default investment strategy right now. When you review your default investment strategy, you're expected to assess the extent to which the performance of the funds meets the objectives that you set and stated in your statement of investment principles. When does this have to happen? Well, the statement and the default arrangement need to both be in place by the 6th of April, so if you haven't already done it, you need to crack on with it. And the existence of your statement and the reviews you've had on it will have to be mentioned in your chair's annual statement, another new requirement that we'll talk about another day. Default investment arrangements are going to have to change very significantly because of the changes from April. In the past, we've tended to set default investment arrangements based on the characteristics of the underlying investments, for example, to dampen down risk or to diversify. We now have to be much more outcome focused, and there are some significant unknowns about the outcomes. When people will draw their benefits and how they're going to draw their benefits and how long the money is going to be invested for. For that reason, it's important to review right now your default investment arrangement. Let's move on to good value. If we thought the default investment arrangement was tricky, good value is even trickier. So first of all, the requirements. Trustees are required to calculate the costs and, so far as they're able to, the transaction costs borne by the members and assess whether they represent good value for the members. Your first assessment will cover the period beginning on the 6th of April 2015, although you don't actually have to carry it out until you pass your next scheme year-end date, although there's a slight bit more leeway for those people whose first renewal, 6th of July. The results of your assessment will have to be disclosed in that chair's annual statement that I mentioned just now and that we'll talk about on another time. And then you must repeat the assessment no less frequently than every year. This is a tricky one. Good value isn't defined in law, either in the regulations or in the primary law. It's not defined by case law, it's not defined academically, it's not even defined by practice. We will have a sense of what good value is, but it's not written down anywhere. It is a subjective judgment, and that's what's going to create some problems. The answer to this is a set of good value principles, or a good value framework, which is starting to be put together by the industry. If you'd like to know more about that, then please do get in touch. If we can help, we'd love to do so. Then you're required to appoint a chair. Irrespective of what your rules say, you are required to have a chair of trustees, whether your board's incorporated or unincorporated. Your chair can be a lay trustee, a professional trustee, an employer-appointed trustee. The only stipulation is that they are a trustee. It can't be somebody who isn't on the trustee board. Often scheme rules specify that there should be a trustee and names who appoints them. If that's the case, that party can still appoint the chair of trustees. If the rules are silent, it's a requirement that applies to the rest of the trustees. For existing schemes, you have to have this chair in place by the 6th of July 2015. For new schemes, within 3 months of being established. And if the chair resigns, you must appoint a replacement within 3 months. The new law gives the chair of trustees no special responsibilities except for one. They have to sign the chair's annual statement. The chair's annual statement is a statement put together by all of the trustees, but it's the chair who has to sign it off. And we'll talk more about that in the next Rough Diamond. Your trustee rules may also give the chair additional powers or responsibilities, and these carry through. The only final requirement in respect of your new chair is that you are required to tell the regulator who your chair is, and they're introducing a new field into their annual scheme return for you to do just that. So thanks for watching this episode of Rough Diamond. We'll be back shortly to talk about some of the other requirements being introduced from April. See you soon.